So let's get started. It looks like most of the people should be in the room now. So before I introduce today's speaker, I will cover a few housekeeping items. Three upcoming events I want you guys to know. Wednesday this week, there will be a Q&A about submissions to the Data for Public Good Symposium, which is slated for March of 2022. Thursday, there will be a workshop offered by NVIDIA on developing radiomic biomarkers using deep learning. Next Monday, the 13th, will be our last seminar for this semester. And MIDAS Computer Science and Engineering and Women in Computing will co-host Katie Booman from Caltech. She was instrumental in visualizing the black hole for the first time. So the seminar will be in person actually at Palmer Commons. The details of all these three events you can find on our homepage. I also want to thank the MIDAS sponsors for the seminar series: Quicken Loans, American Mathematical Society, Microsoft, General Dynamics, and Yazaki. Okay, so now I'd like to turn to today's speaker, Dr. Pauline Kim from Washington University, St. Louis. Dr. Kim is a nationally recognized expert on the law of the workplace and has written widely on issues such as job security, employee privacy, employment discrimination, and judicial decision-making. Her current research focuses on the use of big data and AI in the workplace and their impact on these issues. Professor Kim is the co-director of Washington University Center for Empirical Research in the Law. She's one of the co-authors of one of the leading textbooks on employment law, work law cases and materials, now in its 4th edition. Dr. Kim received both her bachelor's degree and JD from Harvard. Before her faculty career, she clerked in the U.S. Court of Appeals for the 9th Circuit and was the Felix Velarde Munoz Fellow and later a staff attorney at the Employment Law Center Legal Aid Society of San Francisco. So her talk today is very timely. As more and more data science and AI researchers address the issues of bias, discrimination, and social justice from the technical perspectives, some level setting is urgently needed. And I'm sure today's talk will be very informative and thought-provoking for the audience. So now I would like to ask Pauline to share your slides. For audience members, you can put your questions in Q&A at any time. We might get to some of the questions during the talk and also obviously after the talk as well. So Pauline.
Great, thank you so much for that introduction. I almost started without muting myself, and you would think after 2 years, I would have remembered that was one of the first things I need to do. But anyway, thanks so much for having me here. So as the introduction suggested, I am a lawyer and law professor. My training is from law. So let me explain a little bit how I got to this project and my motivation, the motivation for it. So I have long studied in the employment relationship and how law regulates employee-employer relations. And in particular, I have been writing for a number of years about employee privacy rights and the operation of anti-discrimination law in the workplace context. So in recent years, it's become increasingly apparent that technological developments are posing significant challenges in both of these areas. And so my research has sort of turned to focus on the impact of technological tools on workplace privacy and equality and the sorts of legal questions and challenges that they raise. So I'm going to start with a figure that's taken from a study by Aaron Reiki and Miranda Bogan, who are with Upturn. They did the study a few years ago, just kind of mapping out how automated decision tools are being integrated into the employment process. And they talk about what they call a hiring funnel, how employers are increasingly relying on algorithmic tools at every step of this process. And it's a funnel because each step narrows the number of candidates that remain in the process and potentially have access to jobs. And so one of their concerns in the study was to document the different ways in which employers are relying on these automated tools and the potential risks that bias or discrimination can infect these tools in a way that would create unequal access to jobs and job opportunities as candidates are moving through this funnel. So some of my earlier work has focused on things like the sourcing or recruitment phase of this hiring funnel. Employers are increasingly relying on algorithmically driven platforms to advertise job openings or to find candidates. So this includes both through online advertising platforms like Facebook and Google, or by relying on job matching platforms like ZipRecruiter or Indeed, Monster, places like that. And in addition, a number of employers are relying on passive recruiting systems to identify candidates who have not even voluntarily come forward. And so the concern is whether these algorithmically driven processes, which are critical in the sense of controlling information and the flow of information about employment opportunities, can undermine equal access to jobs. So there have been a handful of studies in this area, one by Ali et al. That showed they were studying the Facebook advertising ecosystem, and they found that even neutrally targeted employment ads were delivered in a skewed manner. This is just a handful of the types of ads that they posted and looked at the distribution. But basically what you see is that it appears that these ads are being delivered in a way that reflects stereotypes about who does what kinds of jobs. And this result is likely the outcome of the algorithm, the targeting algorithm, trying to predict based on information that it has about users who's likely to be interested in particular types of jobs. So you might have heard about a lawsuit brought by a number of civil rights groups that led to Facebook creating a special portal for certain types of sensitive ads, housing and employment and credit. And in this special portal, advertisers are not allowed to use demographic information or any attributes that are closely associated with those attributes for targeting ads. And the idea was to try to prevent this kind of bias targeting from occurring. But another study that occurred after that special HEC portal had been put into place showed that the problem really had not been resolved. We had, this is an example of a construction company posting ads, targeting it in a gender neutral way, but the analytics they got back showed that the ad was overwhelmingly being served to male users. So not what the company intended, but again, the algorithmically driven processes of targeting ads appeared to reflect underlying stereotypes. So we have similar concerns with job matching platforms like ZipRecruiter. We don't really know how the matching is done, how someone is being recommended as a great match or not to a company. And so the worry is that if, oops, I'm sorry, lost my slide there. The worry is that if these platforms are not able to actually observe the skills and abilities of the applicants, but instead are basing their predictions on the market behavior they can observe, then what they are doing is essentially just predicting who the employee will like based on who the employee liked in the past. And if there were biases that infected those earlier judgments, these predictions are simply going to be reproducing those biases. Moving beyond the sourcing and recruitment context, employers are using screening and selection tools as part of the hiring process. This is again something I've explored in earlier work, talking about some of the legal implications, and I won't go into detail here. There are, again, risks of bias. There's the well-known example of Amazon's recruiting tool that systematically downgraded women candidates when it was looking for software developers. And there's a number of reasons that these kinds of models can incorporate bias. I think this is well explored in other work. So from a legal perspective, then, how does the law apply? There are two basic theories of discrimination under employment discrimination law. One is disparate treatment, which says that an employer should not be able to take an adverse action because of race, sex, or another protected characteristic. And then there's another theory, disparate impact, which focuses on neutral practices, but that have disproportionate effects on certain groups. If that is the case, that triggers legal scrutiny, and the employer can respond by showing that the criteria it's relying on is job related and consistent with business necessity. So although the disparate impact doctrine would seem to apply to algorithms that have biased effects, and there's a general consensus that that law is certainly relevant in these areas, it's not entirely clear how the law would apply in specific cases. And there are a number of challenges that exist in applying the doctrine to these new tools. So, so where we are today is we well understand that machine learning can create or reproduce societal bias in many domains, not just in employment. There are these sort of famous cases of bias that was found in the recidivism prediction software, in facial recognition technology, in policing algorithms. There have also been examples in the healthcare context, in credit evaluations as well. And so just as in the employment area, there are these broader debates about the extent of existing anti-discrimination law exist in these other areas as well. To what extent can law address these? So there are some, I think there's some rough consensus that in certain contexts, algorithms that have these types of discriminatory bias raise serious legal questions. And certainly there are moral and ethical concerns that arise when we observe these sorts of biases. So then we come to the question of, well, how do we build fair models? So as we've said, algorithms, we know that they can be unfairly biased against historically disadvantaged groups. What do we do about them? And one early suggestion was, well, let's just eliminate any consideration of a protected characteristic like race when building a model. We know that that won't work because there's so many things that correlate with race in our society. And any reasonably rich data set will have variables that can act as a proxy for race. And so there have been other efforts to figure out if there are ways that this kind of bias can be mitigated or reduced through design. And that has led to a general consensus that addressing bias through design is going to require awareness of race or other protected characteristics in the model building process. So this raises a further question. Is the consideration of race or other protected characteristics in an effort to mitigate bias itself going to be considered a form of unlawful discrimination? And that is the main question that is the focus of my current work. So in talking about this question, I want to stop a minute and just define the scope a little bit. My primary focus here is the use of predictive algorithms to make decisions about people, to inform decisions about people in settings that will affect their access to resources or opportunities. At the same time, when we talk about the risk of bias, there is risk of bias along many dimensions, not just race, but also sex, age, disability, and so on. I'm going to focus primarily on the issue of racial bias. Partly that's just for ease of reference, but also from a legal perspective, race is the most challenging setting to sort out and analyze these questions. One other thing I want to clarify is the way in which I'm using the term bias, because bias can be used in a lot of different ways. In this paper, when I talk about bias, I'm simply referring to outcomes that are skewed, that are disproportionately skewed against historically disadvantaged groups. So for example, if racial minorities are being screened out of job opportunities or access to credit at higher rates than whites, that's what I'm referring to as bias. I'm not making a strong claim that outcomes of this kind are always normatively wrong. I think sometimes they are, sometimes they are not. It depends on the reason that bias is occurring in the particular context. But I am starting from that position because I think when these sorts of systemic biases reinforce historical disadvantage, they are matters of concern. And so I think I would make the normative claim that it would be better if predictive algorithms did not produce these sort of biases in socially consequential decisions, unless there's a strong reason that would justify it. It's a big policy and normative question to try to figure out what are sufficiently strong reasons to justify situations where you observe these sorts of biases. And that's a question that really goes beyond the scope of this project. So to go back to my central question here then, is consideration of race or other protected characteristics in order to mitigate bias a form of unlawful discrimination? So there are some scholars who are working at the intersection of law and technology who have suggested that the answer to that question is yes. When race is taken into account to mitigate bias, that is a form of discrimination, they argue, but it may nevertheless be acceptable and legal because it can be justified in some circumstances as a form of affirmative action or under the affirmative action laws. Excuse me. So in this paper, I'm arguing that these scholars have started the analysis in the wrong place. They are assuming that a race-aware debiasing method is a form of disparate treatment and then seek to justify it, whereas I think we first have to ask the question, is a given strategy disparate treatment at all? Does it constitute disparate treatment or discrimination in the first place? So to explain this, let me go back to the legal framework I talked about earlier. So two theories of discrimination, disparate treatment, and disparate impact. I want to delve a little deeper into the disparate treatment side of this now. So under the disparate treatment prong, the law clearly prohibits explicitly discriminatory policies. So for example, if an employer were to say, we just don't hire X kind of people, and that was based on a protected characteristic, that would clearly be a form of disparate treatment and unlawful discrimination. So too are decisions by an employer that may not be explicitly discriminatory, but are invidiously motivated, where the intent of the employer is, we don't want to hire people of a particular race, for example. So another category of disparate treatment is a situation in which an employer engages in an affirmative action plan. In other words, takes account of race in making, for example, its hiring decisions. A number of people have argued that affirmative action programs are a form of disparate treatment in that they take account of race and therefore are a form of forbidden discrimination. And the courts have, in some cases, agreed, but said that yes, even though that might sometimes be a form of disparate treatment because it's a decision that's based on race, that decision may nevertheless be legally permissible if it is justified under the law of affirmative action. So the way these issues arise is there have been a number of legal challenges to affirmative action programs that have been brought by, typically by white plaintiffs or sometimes men challenging affirmative action programs that have benefited women. And the claim that is typically made is that the decision maker, the employer, by taking race or sex into account in ways that benefit disadvantaged minority groups, that those entities have engaged in a form of discrimination based on race or sex that has harmed that plaintiff. So one of the leading cases in the employment area is the Weber case, United Steelworkers versus Weber from 1979. And that involved Kaiser, a steel plant that had a history of near total exclusion of Blacks from skilled craft worker positions, even though about 39% of the local labor market was Black. So they had about 1.3% craft workers were Black in the plant, 39% in the local labor market. And that's because for years, the company had only hired skilled workers with 5 years of experience or more. The way to get that experience was by being a member of a craft union. The craft unions excluded Blacks. And so the effect of these policies together was to essentially exclude Black workers from these jobs. So Kaiser agreed to create a training program for unskilled workers so that they could gain skills for these better paying, more skilled jobs. And the decision was that access would be provided based on seniority, with the proviso that 50% of the slots had to go to Black workers until their percentage in the workforce roughly matched their percentage in the local labor market. So Brian Weber was a white male who sought admission. He was not admitted the first year, and he alleged that he was discriminated against based on his race. And the Supreme Court agreed with that initial premise that the plaintiff, Weber here, had suffered discrimination, but decided that the employer's decision was not necessarily unlawful because it could be justified by a valid affirmative action plan. And in that case, the plan, the court said, was permissible because it mirrored the purpose of anti-discrimination law. It was not too burdensome on the interests of white employees because he had the opportunity to participate in the following year. It didn't put an absolute bar to his advancement. And the measure was temporary and not permanent. So beyond the employment context, the Supreme Court has also considered a number of affirmative action cases in contexts like education and public contracting. And the kind of analysis is similar, although it's under constitutional rather than statutory law. In these cases, the court has said that using a racial classification for a benign purpose in order to deal with racial inequity or try to address past racial discrimination is itself a form of discrimination, and that is unlawful unless it can be justified, that is, it meets the standard of strict scrutiny. And in order to meet strict scrutiny, the entity has to show that the policy was one that promotes a compelling interest that is narrowly tailored, that the means chosen are narrowly tailored to advancing that compelling interest. So there are a number of cases on the constitutional side. The law has been evolving since the 1970s when Weber was decided, but the basic framework hasn't changed. I think the main message, in addition to this idea of strict scrutiny, is that the court has become increasingly hostile to race-based efforts to redress racial inequity, in particular in plans that involve numerical quotas or attempts to maintain some kind of a racial balance that matches the general population. Now, the Supreme Court's jurisprudence on affirmative action has been subject to a lot of debate and a lot of critique. My purpose here is not to engage in that particular normative debate or to try to defend what the Supreme Court has decided. Instead, what I'm doing in this project is simply accepting the existing law, accepting those cases at face value, and then examining the reasoning and trying to figure out what it means for race-aware efforts to mitigate bias in predictive models. So to kind of summarize the legal framework a little bit, the statutory and constitutional inquiries are not identical, but they have a similar structure. And I can summarize them in this way. We start with the question, has discrimination occurred? Has an employer or some other private entity or a public entity engaged in discrimination by taking race into account? If the answer to that is no, then there's no further inquiry needed. If the answer is yes, then the action taken may be unlawful unless it can be defended and justified as a valid form of affirmative action. So recall this slide where I said a number of legal scholars have assumed that race-aware efforts to debias algorithms are disparate treatment, and therefore we should jump to trying to figure out how to justify them under existing affirmative action law. I think it's first important to ask the question in the middle, which I think is the prior question. Are race-conscious efforts to debias models disparate treatment in the first place? Because if they're not, there's no special need for legal justification. So Supreme Court jurisprudence is sometimes summarized, particularly in popular rhetoric, as requiring colorblindness, such that any kind of race-conscious decision-making is considered suspect. But I think that is a mischaracterization of the law. It is true that the court has held that some race-conscious practices are a form of disparate treatment. But if we look closely at those cases, they all involve a particular type of use of race or racial classification in the decision-making process. So in the typical case, the government or private entity is relying on a racial classification in a fairly mechanical way to try to determine which individuals will receive a benefit or resources or a resource. So for example, in the Weber case that I talked about, the employer there used a fixed quota. 50% had to be Black out of all the trainees. There's another well-known Supreme Court case in which a medical school, a public medical school, designated a certain number of seats that were set aside for minorities, and they had to be filled with racial minorities. There was a case in which minority applicants, minority-owned contractors were guaranteed a fixed percentage of government contracts. So in these situations, the way in which race came into the decision-making process was quite mechanical, and it always worked to the benefit of one group at the expense of another. They relied heavily on numerical goals in a way that tended to sort of swamp other considerations. So in these types of situations where the race-conscious practice constitutes disparate treatment, the law is pretty clear. That's where we apply strict scrutiny. Thus, the action will be considered unlawful unless it is for a compelling interest and the means are narrowly tailored. But race consciousness is not the same thing as using a racial classification or engaging in race-based disparate treatment. And the case law also suggests that there are a number of race-conscious practices that don't constitute disparate treatment and therefore don't trigger special scrutiny, legal scrutiny, or require any special legal justification. So for example, employers are permitted to pursue a goal of diversity in their workforce. And in doing so, they can do things like changing their recruitment procedures in order to attract a more diverse applicant pool. They can change their testing procedures if they find out that they are having an unintended and unjustified disparate impact on minority workers. They may design a new test, and in doing so, they may deliberately oversample minority workers in order to ensure that it's fair for all. Oops, I'm sorry. Lost my spot on my slides again. Okay. Supreme Court has also suggested that government entities can do things like engage in targeted outreach to minority communities. They can ensure that the composition of interview panels are diverse in order to try to compensate for bias. They are allowed to take into account the racial impacts of different policies, like deciding where to locate a new school. So these kinds of practices are all race conscious, and they all appear to be lawful, meaning that they require no special justification before a court. And so to answer my original question then, is race consciousness in the model building process disparate treatment at all? It's important to keep in mind that anti-discrimination law does permit some race conscious actions when they are intended to remove arbitrary or unfair effects? In other words, the answer to that first question is sometimes, right? So how do we know then what differentiates a permissible and an impermissible use of race in a decision-making process? Well, this is where it's not entirely clear. On the one hand, I think the court has made very clear that rigid numerical quotas, requirements of racial balancing, and so on are generally unlawful. On the other hand, the case law suggests that changing systems or procedures to remove bias or to eliminate sort of arbitrary barriers are not a form of discrimination. And so there are a lot of gray areas in between where it's uncertain between those two poles. But what the courts seem to be looking for is whether the consideration of race has some causal effect on the decision in an individual case. So how do we apply this framework to predictive algorithms? One important point that I think that often gets overlooked in the legal and the policy literature is the fact that machine learning models emerge from a complex multi-step process. Now, I will say this as a non-technical person who spent some time talking with legal and policy people, but there's a tendency to view machine learning models like this. There's data, you put it in the model, and you get a prediction, and that's the true prediction. In other words, I can ask the algorithm to select the best employee, and the data scientist should be able to come up with the correct model for predicting who will be the best employee. Or I can ask the algorithm to predict who will default on their mortgage, and the machine learning magic will give me the true answer as to who is going to default and who's not going to default. And from this perspective, it seems that if we were to take fairness into account, group fairness considerations into account, and create some kind of a de-biased model, that's somehow a departure from, I'm sorry, I keep losing my slides here, that's some kind of a departure from the true answer. So if you contrast this very simplistic vision with the actual complexity of the model building process, it's clear there's a lot more going on. And this is just a handful of flowcharts I pulled from the internet that different people have posted to try to describe the machine learning process. They're all different from one another. They're all far more complex than what I had up on the earlier slide. So this, I think, is an important insight for the law and policy people because building models is more art than pure technique. That means that there is often no single canonical solution to any reasonably complex problem. Instead, there are a multiplicity of possible models, and those different models will result from different decisions that were made along the way in terms of selecting the data, features, structuring the model, so on. And each of these decisions are going to involve trade-offs and judgment calls. So I think that there are two implications of this for the legal context and for considering the question of the legality of race-aware model building. And one is that one implication is that race and consideration of race is not sort of a mechanical thing. It could come into play at many different points in the process and in many different ways. The second point is that there is no single authoritative true model in many situations. And so that means that there is not necessarily a single baseline model against which to compare a de-biased model. So whether or not a particular form of race consciousness amounts to disparate treatment is going to depend on how race is used. How did the consideration of race enter into the model building process? So taking that framework then and trying to apply it to the different models that are approaches or strategies that have been suggested for de-biasing algorithms means that the question is a little bit more nuanced. It also gets harder here because there are so many different types of de-biasing strategies that have been proposed. I can't possibly give you a comprehensive review of all of them, but I want to just provide sort of a couple of examples of how this framework might apply. And just as an aside here, in doing so, I'm not meaning to engage in any of the many debates about, what's the best measure of fairness, or how should we, how should we define what it is, or, which is a better strategy. I'm really just looking at to what extent is there some legal space? Does the existing law provide some space for exploring these strategies without trying to opine on their desirability, or to suggest that any of these are necessarily best practices in any form? So, so considering this question, when is a disparate treatment when race is taken into account in the model building process? So I think that efforts to debias models by dealing with data problems should not be considered disparate treatment at all. Strategies that involve things like oversampling underrepresented groups, or removing features that are known to reflect human prejudice, those seem to me completely unproblematic. They are really about removing bias, making the model more accurate. They are not, don't amount to anything like disparate treatment, even though they do entail thinking about and paying attention to race. Similarly, I think questions about defining problem definition, or how the target variable is chosen, can have a huge impact on whether or not a model has shows bias in the outcomes, but that designers can and should pay attention to that. But the choice of how to frame the problem is not one that should trigger any kind of legal scrutiny, even if it is done with an awareness of race or racial effects. At the other end of the spectrum, I would say that strategies that are aimed at ensuring proportional outcomes across groups, regardless of the distribution of other attributes, is likely to draw legal scrutiny. These are the kinds of strategies that start to look an awful lot like racial quotas, or efforts to ensure racial balancing that the court has specifically disapproved. What about using race to train the model? What about disparate learning processes that use race in the training process but don't necessarily use it at prediction time? I think that that's a pretty good first cut, that if information about race is used in training in an effort to try to avoid biases, but not use it at prediction time, that will usually, I think there's a good argument that it should not be considered disparate treatment. I want to put a caveat there, though, because to the extent that it's possible to design a facially neutral model with invidious intent, that would certainly constitute a form of disparate treatment or unlawful discrimination. And then finally, there's the question of what about using race at prediction time? What about using race as one of the features that's used to predict outcomes? And I think this is the most difficult question. Now, one view would be that a model that accesses race at prediction time is per se a form of disparate treatment or a racial classification and should be subject to close legal scrutiny. But I should disagree with that. I think that it's not quite that simple, because race can be used in a model in a number of different ways and to different effects. So one way to think about it is, does using race determine individual outcomes? Is race being used in a sense that is determinative, that consistently favors one group regardless of other characteristics that might be the same between two individuals in different groups, different demographic groups? And so the answer to that question, I think, should make a difference, should matter in how we think about this. So certainly if a model is relying on race to produce proportionate outcomes across racial groups, as I said earlier, that looks like racial quotas, that would be a problem. But in more complex models, race can feed into predicted outcomes in a number of different ways. And I think it's important to pay attention to those details. There are been a couple of examples suggested where predictors might differ across different racial groups. Corbett Davies has an article suggesting a hypothetical where housing stability is predictive of recidivism for whites, but not blacks, for example. Or Dwork talks about the example of maybe one demographic group is the most talented students are attracted to finance, whereas for another group, they major in engineering. And in situations like that, if there's no control for the demographic characteristic, the model is going to be less accurate overall, and in particular for the underrepresented group. So if accounting for race in these types of situations would make the model more accurate for the underrepresented group without reducing accuracy of predictions for the majority group, is that discrimination? If doing so would make the model more accurate for both groups, would we call that discrimination? I would argue maybe not, right? The kinds of concerns that underlie challenges to affirmative action programs don't seem to apply here. It's not that the formerly advantaged group is being absolutely barred or kept out of a certain number of slots, or even that they're being consistently and systematically disadvantaged. And so the use of race in that kind of a more subtle way, I would argue we should not necessarily assume is a form of disparate treatment or discrimination. So another way to frame the issue would be to ask, well, does race cause an adverse outcome in a particular situation? And this analysis is relevant in situations when we're discussing distribution of a scarce resource. So to make this concrete, imagine that we have an employer who uses a hiring algorithm and discovers that it has a disparate impact on Blacks. And so it decides to make a change, taking race into account in some way in an effort to de-bias the model. And then a white plaintiff who is not hired says, wait a minute, I think that by making those changes, you have discriminated against me. So essentially, what the plaintiff might be arguing is that, well, if you held all else constant, everything about me is the same, but you switch my race from white to Black, then I would have been hired, then that shows that disparate treatment has occurred. And in legal terms, that argument is called a but-for causation argument. But for the consideration of race, I would have been hired. And I think that that might make sense when we're talking about human decision makers and intentional discrimination. But I think this is the wrong way to look at the causation question when it comes to algorithms. Disparate treatment is about intentional discrimination, but the machine has no intent. So the relevant causal question should be not what would have happened to this individual if the race variable was flipped for that particular person, but the relevant causal question should be what would have happened if the human designers had not taken race into account in building the model. In other words, the relevant baseline from comparison should be what would have happened in the absence of the race conscious considerations in building the model. So I think I'm going to go through this really quickly because this relates to another project that I'm currently working on with some computer science faculty here at Washington University, where we're trying to explore this question experimentally. And basically it's sort of testing this intuition that, you know, sort of a naive point of view somebody would say, if you're moving from a conventional learning model to a group fairness learning model, then if I don't get the resource or the positive outcome under the group fairness model, I have been harmed. But that can't be true by itself. There's implicit in there an assumption that this individual would have gotten the positive outcome absent consideration of the fairness constraints. And we call this perceived impacts, or the perception that I didn't get this now, I think I would have gotten it, and therefore I've been harmed. But in fact, then this goes back to the earlier point, it's not simply that somebody would have gotten it under a single conventional model, but as I talked about earlier, there's actually a whole set of potential models that could be the baseline. In other words, if we can't point to a single correct model, that means that the outcome for that individual really depended on which model was chosen, what data set was chosen, what features were selected, how the labels, what the labels were, et cetera. And so it's, I think, more accurate to characterize the individual as having had some probability of a positive outcome that can be compared with the outcome under the group fairness model. And so what this means is that our understanding of how group fairness models affect individuals has to be a little bit more nuanced. So the project I'm working on with folks here, taking an experimental approach, draws 50 subsamples from a given data set, applies several different conventional models, and then observes the probability that a given individual is allocated the resource or gets the benefit. And we refer to this as natural variation. And if you don't take that natural variation into account, there's what I've called the naive view, perceive these phantom effects of having been significantly harmed, whereas the actual impact, the realized impact on an individual should take into account that natural variation in outcomes in the baseline condition, and in results in many cases in a significantly reduced measure of what that impact is. So I'm going to skip over this because I'm running late on time. But to return to the central point of my paper, I have been arguing that we should, in considering race-conscious model building, that we should not immediately assume that it is a form of disparate treatment that needs to be defended as affirmative action, but instead should first ask the question, is this a form of using race that really doesn't constitute discrimination at all? And you might think, well, maybe this is just semantic, non-discrimination versus affirmative action. Those who have argued for algorithmic affirmative action are basically arguing that these same techniques should be legally defensible as well. But I think it makes a big difference how we think about it. First, practically, as I've shown earlier, once you call something affirmative action, it puts a burden of legal justification on the party that is using that particular tool. And then conceptually, I think it matters because this affirmative action language or frame brings with it the assumption that the previously advantaged group is being harmed by the debiasing efforts. It tends to set up the question as sort of a zero-sum situation. And then it fails to recognize that some debiasing efforts are really just removing sources of bias of unfairness, and they don't entail some kind of special preference in the way that people sometimes use the language of affirmative action to refer to. And then the final thing is, I think it's also important to make this distinction because just referring generically to algorithmic affirmative action obscures the contingency involved in the machine learning processes and the role of human choices in the sort of the ultimate predictions that are produced. So I'm going to stop there, and I'm happy to answer any questions.
All right. So yeah. So thank you so much for this wonderful talk. I want to remind the audience members that you can put your questions in the Q&A. So let me start with a question from Yatin Manerkar. In your opinion, why does so much of the legal discussion around these issues revolve around the views of the Supreme Court as opposed to the laws passed by legislative bodies like Congress? I think this is I want to add a little bit to the question, which is, as you know, the data and algorithm fairness is going to be so important for the society moving forward. What do you see the role really of the court, of the government, of the academics, and the practitioners in the public and private sectors?
Yeah, so the first part when I was talking about employment discrimination law, that was all about statutory law. And the statutory law is very important. The reason why we can't escape the Supreme Court is because, well, for one thing, it's the highest court, so they get the last word on a lot of these issues of interpretation, even the interpretation of the statutes. But the other reason we can't ignore the Supreme Court is because once somebody invokes a constitutional right, that constitutional claim can potentially trump a statutory law or rule. And this is why the Supreme Court has so much power, and why it has been the subject of so much attention, because as the final arbiter of constitutional rights, those constitutional rights sort of set the boundaries on what the legislature can do with statutory rules. And in this particular, so I guess I want to say there's a lot of things that are happening and could be happening around fairness and bias in algorithms that can be dealt with at the statutory level. And I know there are a lot of conversations now in Congress, among members of Congress and policymakers and so on. And I think those are all really good developments. But in particular, when it comes to the use of race and racial categories in making decisions, this is an area where the Supreme Court has been very aggressive in trying to draw boundaries. And in particular, the court has had some hostility to affirmative action. And so I think that it's very difficult to act in this space without paying some attention to what the court has said. Now, that said, again, I think there's some legal academics who have just sort of assumed, well, the Supreme Court is kind of hostile here, so we should view these as affirmative action and try really hard to justify them as affirmative action. I think it's really important, in part, to try to educate the courts about the nature of these technologies, to say, look, just the fact that race was taken into account in building this model does not equate to the traditional forms of what they used to, what they were thinking of when they made these rulings in these affirmative action cases. These are really different techniques with really different effects, and it's important to educate the courts about that, which is why I think it's not helpful to fall into the language of affirmative action. It's much more important to explain to the court what we were doing here was simply a form of debiasing or correcting a problem that doesn't disadvantage anyone. It's really just sort of doing better and doing right given the data and the complexity of the model.
So I see a lot of questions popping up. Let me ask. Ask this question. Can you speak more on DT disparate treatment quota values and how that compares with fairness metrics like statistical parity, true positive rate, false positive rate, since they do put a numerical value while race is involved?
Yeah, so that's a good question. The one thing that the court has spoken to directly is this idea of, I think, what computer scientists call demographic parity, right? So this idea that you have to have proportional outcomes across demographic groups. That is the one area where I think the court has spoken directly and would find that kind of a constraint to trigger this sort of legal scrutiny. Now, what about equalizing false positives, false negatives, predictive accuracy? Those are a little more ambiguous. And again, I think some people have just assumed, well, if you're equalizing based on race, you must be triggering this kind of close legal scrutiny. But it's actually not obvious to me that you are, because if you do something like, it depends on the underlying data, right, and the distribution of the data. But if you do something like equalize false negatives, that doesn't necessarily push you to proportional outcomes. And in fact, depending on the structure of the underlying data, it's not always even clear whether you're advantaging or disadvantaging the majority group or the minority group. So I think those are open questions that we shouldn't automatically assume that efforts to try to equalize or to ensure equal accuracy along these different dimensions necessarily triggers this kind of response. I think there should be, and again, I'm not prepared to sort of to jump deeply into the math of it, other than to say we ought to be having that conversation and thinking a little bit more carefully. Is this particular use of race like the ones that triggered all the concerns by the court, or is it really doing something different that's much more defensible and doesn't raise the same kinds of concerns as the old quotas, the old quotas that were challenged under these affirmative action programs.
Okay, so I love the experiment that you're doing with the computer science folks. I actually was really hoping to see the slide that you skipped and see what preliminary results you got. So related to that, Yatin Manerkar asked another question. Do you feel there's a need for CS machine learning practitioners to verify whether or not certain race-conscious actions constitute disparate treatment? I think this is a really important question because as more and more sort of the technologists and methodologists are starting to address issues of bias and justice, I do sometimes hear from comments from social scientists, for example, saying, oh, his treatment on race is superficial or things like this. Mm-hmm. So how do you think about this question?
Yeah, I mean, I think it's really, so I guess first thing is I think it's great that more and more computer scientists are paying attention to these issues and are digging deeper into it. And I think that is absolutely a positive development. When it actually comes to building things that are going to be deployed and used by decision makers, that's when there really has to be attention to this legal question, right? Of whether the way in which race was incorporated in the process is going to trigger some kind of legal concern or not. But it turns out that there are lots and lots of ways to think about race and to try to de-bias the operation of these algorithms that don't even come close to that line, right? A lot of them have to do with really thinking about problem formulation, thinking about the data that's being used, examining questions of data provenance and representativeness and things like that. And the implication of that is that these tools can't really be built sort of and taken off the shelf and applied to new situations. There is need for more of a dialogue between domain experts and people in CS who are building these tools to understand when this particular piece of this particular data set may have these problems of representativeness, or here are places where bias could come in. In other words, I think there needs to be more conversation across those boundaries, in addition to conversations with law and policymakers, to make sure that the ways in which the strategies that are being used remain kind of within the legal bounds.
Okay, so we're running out of time. Are you open to stay maybe another couple minutes?
Sure, I'm happy to say a few more.
Yeah, okay, so let's answer two final questions. One is whether you see the diversity of the team has anything to do with creating algorithms that are found to be discriminatory. Another is if somebody believes they are discriminated against by an algorithm, mm-hmm. How can they build a legal case without being able to see the data?
Yeah, right. Great questions. So by the diversity of the team, I'm assuming that the questioner is talking about the demographic diversity of the team, although I'm not sure, but certainly the diversity of team across multiple dimensions will help. And again, as I said earlier, really engaging with domain experts, understanding the context in which an algorithm is going to be used, if it's going to be used for socially consequential decisions, is really important. And then I think demographic diversity of the team can make a real difference as well, because some of those ways in which, for example, the definition of the problem, the way in which the problem is formulated, and the way in which that problem formulation may implicitly bias the outcome is not always going to be obvious to everybody. But having different perspectives and people with different experiences, it's going to be more likely that those kinds of concerns will be noticed, or will be surfaced or will be questioned, right? In terms of if somebody thinks they've been discriminated against by an algorithm, what do they do? How do they build a legal case? So this is one of the challenges. In the legal arena, we have been having a number of debates back and forth. How does existing law apply to these different algorithms? Would the disparate impact theory apply to a discriminatory employee selection tool or a bias tool? And how would that play out? But there is this earlier prior problem, which is the really practical one, which is exactly this question. If you think you've been discriminated against, like, how do you even know that? How do you go about trying to prove it? And unlike traditional forms of discrimination, where somebody would encounter a decision maker face to face, and then maybe there was a comment or something about the way they were treated, or they were treated differently than their friend who also applied for that job, and they kind of get an inkling that something was going on. With discriminatory algorithms, it's really, really difficult because all you know is your own, and oftentimes it's just an interaction with some kind of an interface, right? An online interface. And so traditionally, the enforcement of discrimination law has just relied on individuals to come forward and say, hey, I've been discriminated against, I want to bring a suit. But the challenges of detecting and proving algorithmic bias suggests that we need more regulatory tools, that it's more likely that these kinds of issues can be effectively addressed by having agencies that can kind of see the big picture, right? And maybe that's by having some kind of data disclosure requirements where a regulator can examine for discriminatory effects and raise situations in which there appears to be bias that is disadvantaging certain groups. So, and again, that is like in my area of employment, the Equal Employment Opportunity Commission is the federal agency responsible for enforcing employment discrimination law. And they have started to take steps now to look into this, to figure out what role they might play in auditing what employers are doing and to ensure that discrimination is not occurring under the guise of these technical tools.
Okay, so yeah, so thank you so much for this wonderful talk. I think we will wrap up here. And thank you for all the audience members for being here, and we'll see you next Monday to hear about black holes.
Great.
Yeah, thank you, everyone.
Thanks.